Hey everyone, Chris Archer again. Wanted to take some time today and talk to you about another issue that comes up a lot. A question I get from my clients, even with young children, is whether or not they are required to pay for their children's college expenses, tuition, room and board, books, when their children reach the age of 18 and beyond. Now, this question has a storied past in South Carolina, and so I want to walk you through that so that hopefully you can have a better understanding of it by the end of the video. The first time that this issue was addressed by the South Carolina courts was in the 1970s, 1979, a case called Reisinger v. Reisinger, where the court held that a parent could be obligated to pay for college expenses for their children or their child beyond age 18, obviously. And they the court iterated four factors that they would look to determine whether or not it was appropriate to order a parent to pay those expenses. The first factor that the court said we should look to is whether or not the child will benefit from a college education. This one is kind of a check the box factor because you're going to have a hard time proving that a child would not benefit from a college education. I think as a society we recognize the benefits of education and encourage more children to attend college than don't. So that is going to be a factor that's going to say yes, this child should receive help, compensation from their parents, and helping to attend college. The second factor the court said that we should look to is whether or not the child demonstrates an ability to succeed in school or at least earn satisfactory grades. And so what this means is that the child's got to be able to demonstrate that they can do well and succeed in college before the court's going to obligate a parent to pay those educational expenses. Third, the court said we should look to whether or not the child would otherwise be able to afford going to college. And so what this means is that only in cases where the child can establish that there is no other way financially that they can attend college, then the court will obligate the parent to pay for that schooling. And so this one's a difficult burden for the child to establish. They've got to prove that there's no way possible for them to go to school unless the court makes their parent pay for it. Lastly, the court's going to look to the parent's financial ability to pay, but the courts have said that this is a lower factor than the child's need for the finances to go to school. So while the court will look at the parent's ability to pay, they're going to look at the child's need before they look at the parent's ability. Now, I told you earlier that this was a storied issue in South Carolina, and so it's important to note that in 2010, the Supreme Court of South Carolina held that Reisinger was unconstitutional because it treated children of divorced parents differently than children of undivorced parents. And it said that this disparate treatment between children of different classes was unconstitutional. However, only 2 years later, the court reinstated Reisinger in a case called McLeod v. Starnes. And so Reisinger is now the law of the state once again. And McLeod, the court, explained that what it is attempting to do is to provide for children who otherwise would have had their parents paying for college, for that to continue, and that if divorce and divorce alone is the only reason that the parent or parents are not paying for college, then the court seeks to give the child a remedy to get that support back from their parents. So looking back through the history of these cases, once Reisinger was reinstated, of course, all of the cases that came after Reisinger were also reinstated. And that includes a case called Hughes v. Hughes, which expounds upon the third factor I mentioned earlier in Reisinger, which is whether or not the child could otherwise afford to go to school. And it explained that a little bit further, the court did in Hughes, so that we know what we're looking for in making that determination of whether or not the child can afford. And so, two things we're looking for are the availability of scholarships, grants, and other monies available to the child that may help them pay for school. And second, we're looking at the ability of the child to earn an income. This includes during the summer, vacation periods, part-time work during the school year. And so the child's going to, under most circumstances, be able to, if they're able to go to school, then they're likely going to be able to earn at least somewhat of an income. And in those cases, the court has said that the parents should not be obligated to pay anything for the school, or if they are, not obligated to pay much. So to answer the question of whether or not parents can be required to pay for college education expenses in South Carolina, the answer to that question is yes. But there is a list of factors that we have to look to determine whether or not that is appropriate. And looking at the third factor in Reisinger specifically, accounting for the child's requirement to prove that they're unable to otherwise provide for those costs, provide for themselves and pay those college costs, that's going to make it difficult for the child to establish a case to receive a substantial amount of money from the parent to pay those expenses. One other thing I wanted to touch on real quick while we're talking about this issue is that when parents divorce prior to the child reaching age 18 or emancipating, and they agree in their divorce agreement to pay or divide the child's college expenses, that agreement incorporated into a divorce order remains binding on them and can supersede the requirements set forth in the Reisinger case. So, for example, if the father agrees to pay all college expenses, reasonable college expenses, or half of all the reasonable college expenses, then that alleviates the child's burden later on to prove that they can't otherwise afford college. So whereas under normal circumstances the child would have to prove that they can't earn an income for whatever reason, or they can't obtain federal loans, student loans, or financial grants for them to attend, that divorce agreement could trump all of that and alleviate them of that burden. So an important thing to note when entering into an agreement for a divorce, even when the children are not anywhere near college age, something to be thinking about going forward. So I hope that answers some of your questions about whether or not parents can be obligated to pay for college expenses for their children. If you have any questions about that, feel free to shoot me an email, give me a call at the office. If I can't answer your question or help you out, then I will point you in the direction of somebody who can. I hope you have a great day. Thanks.